and save this. So Donald Trump is trying to use yesterday's Supreme Court ruling to get his recent felony conviction thrown out in New York. Chuck, do they have any case here? He also, Lisa, was not president, right? It was during the campaign of 2016.
In a desperate bid to escape accountability, Donald Trump is trying to leverage a recent Supreme Court ruling to overturn his felony conviction in New York. Trump's legal team claims that the new ruling renders some evidence inadmissible and has requested to postpone his sentencing. It's a Trump maneuver we've seen fail one too many times. Let's dive into the details
and save this. So Donald Trump is trying to use yesterday's Supreme Court ruling to get his recent felony conviction thrown out in New York. Two sources telling NBC News in a letter to Judge Juan Merchan yesterday, Trump's lawyers claim, given the Supreme Court's decision, some of the evidence presented by prosecutors during the trial now should be inadmissible. They also requested the former president's July 11th sentencing be postponed. That's a week or so from now, so they can brief the judge on their argument.
Trump's legal team is grasping at straws, trying to leverage a Supreme Court ruling to invalidate his felony conviction. It's a desperate move, a Hail Mary to delay the inevitable. Trump's lawyers claim that this new ruling renders some of the evidence inadmissible, but it's just another tactic to buy time and create confusion. They've even requested a postponement of his sentencing, hoping to stall the process further. This is classic Trump, always trying to wriggle out of accountability using any means necessary.
Chuck, do they have any case here?
On one hand, I think the letter to Judge Merchan was entirely predictable. On the other hand, I think it's entirely wrong. I mean, if you look at the Supreme Court's decision from yesterday, Willie, right, the conduct that underlined the New York case seems to me to be purely private. And so perhaps Judge Merchan grants them a hearing, but I have a hard time imagining that they would prevail on it. This seems to me the type of case that a president ought not be immunized from.
Trump's move to use the Supreme Court ruling as a shield is both predictable and fundamentally flawed. The Supreme Court's decision doesn't provide a get-out-of-jail-free card for the kind of private misconduct that Trump engaged in. Even if Judge Merchan entertains a hearing, the chances of Trump prevailing are slim to none. This is a blatant attempt to exploit the legal system and evade justice.
He also, Lisa, was not president, right? It was during the campaign of 2016. So how does that factor in?
Well, so first of all, I don't think that they're necessarily asking for the case to be dismissed because of presidential immunity. What they're saying is that the trial and the verdicts that arose from it were faulty because Merchan admitted evidence that under this ruling no longer can be admitted. What does that evidence look like, Willie, given that he was not president for most of it? Well, for example, the prosecutors relied on a series of tweets that Donald Trump issued in 2018 after the truth about the Stormy Daniels payments came forward. Those kinds of tweets, my understanding is Donald Trump's lawyers are saying you should never have admitted that evidence. And because of that, and because of today's ruling, the entire verdict is in question. It's not he should have been immune because of this ruling. It's more like the verdict is predicated on the admission of evidence that this ruling tells us should never have come into the case.
Trump's team isn't exactly claiming presidential immunity, but rather attacking the validity of the evidence admitted during the trial. They argue that tweets from 2018 should never have been included. This is a desperate attempt to undermine the verdict by nitpicking the evidence presented. It's a weak argument that overlooks the fact that the evidence was relevant and damaging. Regardless of this new ruling, Trump's lawyers are essentially trying to rewrite history to suit their narrative, ignoring the gravity of the misconduct itself.
The Supreme Court's immunity ruling not just impacting the former president's federal election subversion case. Donald Trump's legal team is also using it now to challenge his hush money trial conviction here in the state of New York, arguing that Donald Trump's official acts, which are now immune, were used as evidence against him, and the ruling found they can't be.
Trump's legal team is playing a desperate game, trying to use the Supreme Court's immunity ruling as a get-out-of-jail-free card for his hush money conviction. They're arguing that acts from his presidency, now deemed immune, were wrongfully used as evidence. It's a classic Trump move, twist and turn every ruling to fit his narrative, hoping to escape the consequences of his actions.
What we have in New York is a situation where a substantial number of official acts of the presidency, things that we believe are official acts, were used as evidence to support the charges in that New York trial. We believe that that corrupts that trial. That indicates that that jury verdict needs to be overturned, and at the very least, we deserve a new trial where those immune acts will not come into evidence.
The argument here is laughable. Trump's team is basically saying that using evidence from his presidency somehow invalidates the entire trial. They want a new trial free from this evidence. It's just another ploy to delay justice and manipulate the system in his favor.
So that sentencing, of course, was supposed to happen a week from Thursday. Donald Trump's legal team hoping to delay it. And we're just getting some more information on that. The Manhattan DA's office now weighing in. I want to go to my colleague, Kara Scannell, who has more on this breaking news. So, Kara, where does the DA's office stand here?
Trump's team is scrambling to delay his sentencing. It's all about buying more time and creating chaos. The Manhattan DA's office is weighing in, but we all know Trump's playbook by now. Stall, confuse, and hope for a miracle.
So the Manhattan District Attorney's Office has just weighed in, and they say that they don't oppose postponing the sentencing in order to allow Trump's legal team to brief this issue following the Supreme Court's decision. So what the DA's office is saying is that they still think Trump's legal team's position is without merit, but they said they don't oppose the briefing. So they are saying they would agree to a briefing schedule where Trump's team would file their briefs first. The DA's office briefs would be due on July 24th. Now, Trump's team is asking for oral argument. So if the judge agrees to any of this, then the oral argument could follow. So we're looking at Trump's sentencing potentially being postponed into August. But ultimately, this is up for the judge, Juan Merchan, to decide. He has not weighed in on this. But since the DA's office is not objecting to it, it is possible and likely that he would postpone the sentencing. Now, we also obtained the letter that Trump's legal team sent to the judge. We're saying that they wanted to brief this issue following the Supreme Court's decision on presidential immunity. And what they're highlighting are specific parts of testimony and evidence that came into the trial. Among them, they said Oval Office conversations. One piece of testimony that the jury heard was Michael Cohen saying that he met with Donald Trump in the Oval Office, and that's where they discussed the reimbursement scheme. So they're arguing that that sort of evidence should not have come in and should not have come before the jury in this case. Now, they had initially raised this question of whether evidence should come in over presidential immunity because they had already knew they were challenging it. But the judge in the case said they'd done it too close to trial, so he didn't even consider that ahead of time. Now the question is before him now that the Supreme Court has ruled, and we'll see what he does. But the next step here is going to come from the judge to see if he does adapt this schedule that the prosecutors are okay with, and if he does then postpone Trump's sentencing to sometime in the future. Erica?
The DA's office, while dismissing the merits of Trump's legal arguments, isn't opposed to a delay. This is typical, allowing Trump's team to file their briefs first and then scheduling oral arguments. This means we might not see sentencing until August. The DA's stance doesn't signal agreement with Trump's arguments but merely a willingness to follow due process. Trump's lawyers are pulling every trick to challenge the evidence, like Michael Cohen's Oval Office testimony about reimbursement schemes. It's a last-ditch effort to muddy the waters and push the sentencing further down the road.
And they remind me that what prosecutors are asking for is a deadline of July 24th?
They want their briefs to be due by July 24th. So then it will be in the judge's hands. He will decide whether he thinks there's any merit to this. He could decide to hold oral arguments, but the timeline from then on is up to the judge. Now, once he issues his ruling, assuming he sides with the prosecution, then the sentencing would go forward. Of course, if he sided with Trump's legal team and overturned the conviction or said a new trial was needed, then Trump's sentencing would be put off because it wouldn't be required.
The next crucial date is July 24th, when the briefs are due. It's all in the judge's hands afterward. If the judge sides with the prosecution, sentencing proceeds. If Trump's team gets their way, we're looking at a possible overturned conviction or a new trial. It's a high-stakes game of legal maneuvering. Trump is banking on these delays to keep him out of prison. But justice has a way of catching up no matter how many tricks are played.
Already decided it, she would have been far more restrained. For example, she was okay with using evidence from official acts in a prosecution for unofficial acts, but the rest of the majority decided that that was out of bounds. I think one of the best ways to understand how this applies is what they said about the Trump case. So in the Donald Trump January 6th indictment, the court has now said that the whole section about Donald Trump allegedly trying to co-opt the Justice Department into sham investigations of bogus claims of fraud, that has been excised from the case. That is out because the court said that the conversations between the president and the attorney general are clearly official acts. Now, what does that raise the specter of? That raises the specter of any president ordering his attorney general to conduct a bogus investigation because of a bribe or because of some political motive, and prosecutors can't question that now. So that's clearly a troubling scenario.
Trump's team must be doing backflips over this ruling. The idea that a president can order the attorney general to start fake investigations for political gain? and now have that be immune from scrutiny is outrageous. It sets a dangerous precedent where corruption can thrive unchecked under the guise of official acts. This decision is a legal shield for presidential misconduct, essentially giving future leaders a free pass to abuse their power.
But on some of the other issues in the indictment, for example, Donald Trump's conversations with Mike Pence, pressuring Mike Pence to try to stop the certification on January 6th, what this decision says is those conversations are presumed immune because a president's conversation with a vice president is ostensibly an official act when they're talking about their official duties, but it's possible prosecutors can come into court and make a case for why they're not immune. For example, it really wasn't Mike Pence's official duty to stop the vote, as he said many times, and he was actually presiding over the Senate. He wasn't acting as vice president at that moment. So that's the kind of thing that can be litigated. Another example is the president's public statements are deemed to be presumptively official acts in this decision, but there are other aspects of things that the president says that could be deemed private acts in the context of this indictment and otherwise.
The Supreme Court ruling suggests that Trump's pressure on Pence to halt the January 6th certification could be considered an official act, giving him immunity. But anyone with a brain can see that this wasn't part of Pence's official duties. Trump's desperate attempts to cling to power aren't protected by the sanctity of the office. They're abuses of it. This ruling may force Judge Chewin to sift through every word and action to distinguish official from unofficial acts, prolonging the judicial process and giving Trump more room to maneuver.
So what's going to happen next in the Trump case is that Judge Tanya Chutkan down here in Washington is going to have a hearing or a series of hearings or even a mini trial to look at the evidence in this case and decide which of this stuff is official acts and which is unofficial acts, what part of this case can go forward. I know from my reporting that the special counsel's office was very disappointed in this ruling, although they didn't issue a statement or comment at all. And there's a lot of concern at the Justice Department that this case can't go forward at all, and it may even affect the classified documents case. But what we might see is a lot of airing of the evidence before the election in Judge Tanya Chutkan's courtroom down here in D.C.
Trump's legal saga continues, with Judge Chewin having to untangle this mess of what counts as official versus unofficial acts. The special counsel's office is rightfully worried. This ruling throws a wrench in their plans. If these immunity claims stand, Trump could skate past accountability for his actions. The prospect of these hearings dragging out into election season only adds to the chaos, keeping Trump's criminal antics in the spotlight as he tries to paint himself as a victim of political persecution.